Hello everyone, today I'll be sharing another legal story with you. So basically what happened on 22 September 2025 is that the Supreme Court was dealing with the case of Abhimanyu versus the state of Kerala. Okay, and in order to understand this case of Abhimanyu versus state of Kerala, so let's understand the facts of the case first. Okay, so firstly, what happened in this case, the trial court granted bail to the accused. Okay, so bail has been granted to the accused. Okay, and the respondent, that is the state. Okay, so the state, they file an application under section 439(2) of the CRPC. Okay, so under section 439 subsection 2, a application is filed before the sessions court for the cancellation of bail. So since the trial court has granted bail to the accused, the state moved an application before the sessions court for the cancellation of bail of the accused. Okay, the sessions court declined the cancellation of bail application. So Supreme Court declined the cancellation of bail application. Okay, after that, after this cancellation of bail application, a similar application for cancellation of bail was filed before the Kerala High Court under section 482 read with section 439 subsection 2 of CRPC. Okay, after hearing the bail application, the Kerala High Court set aside the bail granted. So the bail of the accused was set aside. Thereafter, an appeal was filed by the appellant. Okay, who is the appellant in our case? Appellant in our case is accused. And why he is filing the appeal? Because the High Court, they set aside the bail granted, and against judgment of the Kerala High Court, the accused whose bail was set aside by the Kerala High Court, against that judgment, the appellant, that is the accused, is filing an appeal before the Supreme Court. Okay, so an appeal before the Supreme Court is filed against the judgment of Kerala High Court cancelling the bail application of the accused. Okay, when the appeal was filed before the Supreme Court, the appellant, okay, who is the accused, he challenged the maintainability of the application filed before the court. So basically the appellant, he challenged the maintainability of the application that was moved by the state before the Kerala High Court. Okay, and he contended that since the session court rejected the bail application, okay, so since the bail application is rejected by the sessions court under section 439(2), okay, the second cancellation application that is filed before the High Court cannot be filed under the same provision. Okay, so the contention of the appellant was that since the application under section 439 subsection 2 is filed before the sessions court, okay, under the same provision, the application before the Kerala High Court cannot be filed. Okay, these were the contentions of the appellant. Okay, instead the proper recourse is to challenge the sessions court order via revision petition. So either the state can file a revision petition before the Kerala High Court, or they can invoke the inherent jurisdiction of High Court under section 482 of CRPC. So they have two options, that is the state has two options, that either they can file revision petition before the Kerala High Court, or they can invoke the inherent jurisdiction of High Court under section 482 of CRPC. After hearing the contention of the appellant, court disagreed with the contention of the appellant and noticed that since in the present case an application before the High Court was filed under section 482 read with 439 subsection 2 of CRPC. Okay, since in the present matter the application is filed under section 482 read with section 439 subsection 2 of CRPC, there is no bar on High Court from exercising inherent jurisdiction under 482 CRPC. So since the application is filed under 482 read with section 439 subsection 2, there is no bar on the High Court from exercising the inherent jurisdiction under section 482 CRPC, right? So the High Court can use its inherent jurisdiction, there was no bar, and therefore the court disagreed with the contention of the appellant. Okay, Supreme Court held that an application for cancellation of bail can be moved before the High Court invoking its power under section 482 CRPC read with section 439 subsection 2 of CRPC. Okay, so a bail application can be filed under this section. Okay, However, after hearing the appeal, whole appeal on the merit, the Supreme Court, they set aside the order of the High Court, right, preferring to lean in favor of liberty rather than its curtailment. So ultimately the Supreme Court, they set aside the order of the High Court of cancelling the bail application, okay, but they upheld the order of the trial court of granting bail to the accused, preferring to lean in favor of liberty rather than its curtailment. Okay, this was done on merits, okay, after hearing the whole appeal, okay, but on point of the maintainability of the application filed by the state under section 482 read with section 439(2) of CRPC, the Supreme Court clearly said that an application is maintainable, right, and thus the High Court is not barred from exercising its inherent jurisdiction under section 482 of CRPC. Okay, this is what happened in the case. Thank you so much.